Welcome back. Today we'll be dealing about another topic in patent law, that is non-patentable inventions. Now, talking about the non-patentable inventions, the statute or the Patent Act of 1970 has meted out a lot of exceptions to the general rule of patenting. That is, there is an elaborate section dealing about what cannot be patented. So this is an exclusionary section, and this is also known as the second tier of qualifying standards, because the first tier being the novelty, industrial application, concepts, etc., which we dealt in the earlier slides. So for an invention to acquire patent right, there should be an inventive step, there should be novelty, there should be industrial application, etc. And along with that, even when that first step is crossed, the next step is to ensure that the invention does not fall into any of the sections or the clauses in section 3. So there are two standards set. So this is the second standard. So we'll move on to each clause one by one. First one is section 3A. Let's look into that. So any frivolous invention or obviously contrary to well-established natural laws, they are exempted from getting any patent. Frivolous invention in the sense that it could be an inventive step, it could be something which nobody knew till then, which could be something which has not formed the prior art, but still it is not anything useful, it does not have any kind of commercial viability, or it is totally useless, totally frivolous, or totally trivial. In that sense, it cannot gather any patent rights, or it should be obviously contrary to well established natural laws. Natural laws, in the sense that the gravitational theories, the laws of motions, there are a lot of natural laws, natural theories, scientific theories, etc. So, if it is very obviously contrary to all these theories, any invention that is very obviously contrary to all these theories will also be denied patent protection. Yes, of course, you have to, after you put the claim, obviously there will be a procedure wherein you can talk about its effectiveness, but then if to the patent office it is felt that it is contrary to well established natural laws, then obviously patent rights will not be granted. For example, a ball defying the laws of gravity, in the first place it cannot happen, and it is not very obvious. So if you are able to prove that, of course, it has an enhanced efficacy, and there's an inventive step, this is a new thing which nobody knows. If you are able to, if the patent, if the applicant is successful in getting that, in convincing that claim to the patent office, then obviously we'll get a patent. But if it is very obvious that you cannot have such a kind of invention, then it will be not granted any kind of protection. Next one is section 3, clause B, that is anything contrary to public order or morality, or which causes serious prejudice to human, animal, or plant life or health, or to the environment. So this is actually a section for public interest. Contrary to public order is, or morality, something that came before the patent office, was an invention for a medicinal powder prepared from the remains of a dead body. That is, a week after the body is buried, it will be exhumated, and from that after that process, certain things were gathered from the dead body, and a medicinal powder is made. So it is said to have some kind of medicinal therapeutic efficiency, but then despite of it was not granted patent protection, because it was held to be against public order and against morality. It was like defying the dignity to dead bodies. So because of all these reasons, it was not granted patent protection. And next one is, uh, public order is a very wide term. Like, you can include so many things. Any invention for food adulteration, counterfeiting coins, housebreaking, or conducting a robbery. There are so many things which is against the public order, even though there could be a very good inventive step. So, in such cases, patent protection will not be granted. That is, any invention which is more in advancing the commission of a crime, all these things will not be applicable or acceptable. The next one is which causes serious prejudice to human, animal, or plant life or health or to the environment. So, for the general environmental health, the human, animal, the plant, the protection of life on earth. So, anything which is contrary to that, that will also be not granted any patent protection, no matter how effective the invention is. Next one is Section 3, Clause C. So, let's see. Mere discovery of a scientific principle, or the formulation of an abstract theory, or discovery of any living thing or non-living substance occurring in nature. So this says that this marks a stark distinction between the discovery and invention, because we know that patents are granted only for inventions and not for discoveries. So if you're discovering a scientific principle, a theory, not only scientific principles, any kind of principles in any discipline of any branch of knowledge. So if that discovery will be something which is not known to anybody, no matter how radical it is, no matter how life changing that can be, it cannot be patented, because once it's patented, it cannot be made use by anybody else without the permission of the patent owner. So because of that reason, it is not coming under the purview of Patents Act, or it will not be granted any kind of protection whatsoever. For example, if Albert Einstein was living in this century and he's purporting, he's identifying or discovering the gravitational laws, or Newton is finding out, discovering the laws of motion, they'll not be granted any kind of patent for that particular discovery alone. Or the formulation of an abstract theory, because there are a lot of theories given by a lot of scholars, eminent personalities, luminaries. All these things are to be for educational purpose or something more done. And one thing in regard of scientific principle is that if the principle, using that principle, you are making a product or a process, then obviously that will be granted patent protection. So simply discovering a scientific principle is not enough, but if you are going a further step and making a new product or process which is not forming part of the prior art, then obviously you will get the benefits of patent. And also the discovery of any living thing or non-living substance occurring in nature. Many people would not be, or the world might not be knowing so many living things, so many species of plants and animals that are occurring naturally in the environment. So even you are taking all the trouble and skills to discover so many things, living things, etc. You will not be granted patent for that, because it is forming naturally in the part of nature. You are just happening to unfold it after a long period of time. That's it. So that is also not practicable. So here, any naturally occurring microorganisms will also fall under the third part of the clause, meaning that naturally occurring microorganisms cannot be patented. That's Section 3 Clause C. Next one is Section 3 Clause T. Now, Section 3 Clause T is a very wide section having very wide ambit, and there have been a lot of judicial interpretations at length regarding the ambit of Section 3 Clause T, what different words in Section 3 Clause D means, its interpretation. And in 2005, this section had been amended, including more and more clauses into it. So, how about that? How is it going to affect the patent regime in India? So all these things have been discussed and deliberated by various courts, and the main case is Novartis AG versus Union of India. And especially this has come into light. These interpretations became very imperative in the case of pharmaceutical patents. So we'll be dealing with that in a specific lecture itself later on. So I'm not going deep into the intricacies and not meticulously going into the meaning of Section 3 Clause D. I'll just say what Section 3 Clause D is. This we'll be dealing with in the next video. So first one is mere discovery of a new form of a known substance which does not result in the enhancement of the known efficacy of that substance. So here also you find the word discovery. What are you discovering? A new form of a known substance, and which does not result. Okay, you're finding out a known substance, but then there is a bar. If you're not, it is not resulting in the enhancement of the known efficacy. That word efficacy, the test of efficacy, was propounded in the case Novartis AG versus ENF in the Novartis case. We'll discuss that later, of the efficacy of that substance. So the term efficacy, so where do you fix the limit of efficacy, and what do you mean by efficacy, it was all discussed by the courts. So that is the first part. Next one is there are a lot of ors. You have to clearly mention and look where the or is coming. Next one is the mere discovery of a new property, or so it is the efficacy of that substance or the mere discovery of a new property or the new use for a known substance or of the mere use of a known process, machine or apparatus unless such known process results in a new product or employs at least one new reactant. And there's an explanation. For purposes of this clause, salt, esters, ethers, polymorphs, metabolites, pure form, particle size, isomers, mixtures of isomers, complexes, combinations, and other derivatives of known substance shall be considered to be the same substance unless they differ significantly in properties with regard to efficacy. So, you find a lot of terms recurring, even though in the first reading it seems to be very easy to understand. It is not like that. There are a lot of it's a wide the ambit and the scope of each clause and each part of the clause is quite different. We'll be dealing with that in a later video because it requires in length a discussion for that alone. So this is about Section 3 clause, and many patents, especially for pharmaceutical patents, have been denied just on the basis of Section 3 Clause D, because Section 3 Clause D also deals with avoiding evergreening of patents. We'll come to evergreening of pharmaceutical products especially. So we'll come to that also, that concept also later on. So that's about Section 3 Clause D. Next one, we'll come on to Section 3 Clause E, that is substance obtained by mere admixture, resulting only in the aggregation of the properties of the components thereof, or a process for producing such substance. So this is what is Section 3 Clause E. Now the word used is aggregation of the properties. So that means if you are combining two or more properties, and if there is no synergistic or enhanced effect, then there will be no that cannot be patented. So in common parlance we say that 2 plus 2 is equal to 5. That is, there should be a synergic value addition, that one is a synergy. So if such a kind of synergy cannot be claimed, cannot be made effective through your invention, then it cannot be patented. So it is on the burden of proof or the of claiming is on the applicant to show that there is synergical efficacy. So mere substance obtained by mere admixture, and for example the soaps, the detergents, lubricants, all these are combination of a lot of chemical substances, but once they are admixed together, then there's an efficacy on its own happening. The synergy function, it has to be more surprising than what was known. An admixture should have a new function different from that of its constituents. This happens in the case of soaps, detergents, lubricants, etc. So for all those, patent protection is granted because they are able to show that synergistic value addition. But here, if you don't have such a thing to show, then obviously you'll not get any kind of patent protection. And any process for producing such substance will not also be granted any kind of patent protection.